This time we will start our hearing, and we'll begin by all stand and we'll say the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, at this time I will ask Mr. Parker to enter the documents into record.
Commissioners, we have the following documents to enter into the record. A petition to contest election of Michael R. Kelly as Republican candidate for Upshur County Sheriff. That was filed by David D. Taylor or counsel on his behalf. That was recorded on May the 25th at 11:59 a.m. We have notice of contest of election of Michael R. Kelly as Republican Party candidate for Upshur County Sheriff. That was served on Mr. Kelly on May the 29th. That was prepared by Mr. Taylor or counsel on his behalf. We have the respondents' reply to petition to contest election of Michael R. Kelly as a Republican Party candidate for Upshur County Sheriff, and objections to petition to contest election of Michael R. Kelly as a Republican Party candidate for Upshur County Sheriff, and respondents' motion to dismiss. That was recorded on May the 31st at 10:43 a.m. By Mr. Kelly or counsel on his behalf. We have notice of withdrawal of candidacy filed by Michael Kelly on July the 12th at 4:04 p.m. In the office of the Upshur County Clerk. And we have opposition to Michael Kelly's motion to dismiss and reply in support of David D. Taylor's petition. That was received in the mail by the office of the Upshur County Clerk. It was opened and date and time stamped July the 16th at 4:25 and was recorded yesterday, July the 17th. Those are the documents for the record. Mr. Tenney?
Okay, are there any objection to the documents presented by Mr. Parker?
I do, Your Honor. Your Honor, I guess is what we'll be calling you today, Mr. Commissioner, Mr. President. As it relates to the final document, I still have not been served with the response or the opposition brief. Mr. Stranko gave me a courtesy copy yesterday evening, and in fact, I didn't know that we would be doing anything here today other than dispensing with this matter. I did receive that, but it states I've been served. I've not been served. So, in as much as I've not received proper notice of that document, I do put that objection on the record.
Okay, we will take your objection under advisement. Was there others?
Your Honor, I have no objection to the record as it currently stands. I do intend to tender additional exhibits during the course of these proceedings today.
Okay, thank you.
Thank you.
With those being said and noted, we will order the documents into record. And I might start by saying that the Commission will not hear any Hatch Act issues. The only issues that we will be hearing today will be concerning state law related to this case. This time we'll take appearances and ask the parties to introduce and identify themselves to the Commission.
May it please the Court, Your Honor, my name is Charles Crooks. I'm a lawyer. I'm here today on behalf of my client, David Taylor, the petitioner in this matter.
Frank Hartman on behalf of the respondent, Michael Kelly.
At this time, Mr. Crooks, you may present your case.
Mr. President, if I may, before I will renew at this time our motion to dismiss. It's been received by this court inasmuch as, and I'll state my reasons briefly on the record. You have the documents before you. You've reviewed them with your counsel, and your counsel can competently advise you and how to proceed on this matter. But in my underlying petition, or the response to my petition, we filed a motion to dismiss. The motion to dismiss is essentially upon the grounds that Mr. Kelly is being alleged to have violated West Virginia Code 7-14-15A, I think, regarding candidacy. He shall not be a candidate for office. And inasmuch as Chief Deputy Kelly is exempt from civil service, this section does not apply to him. The entirety of the Article 14, 714.1 et sec. Is about civil service for deputies. Chief Deputy Kelly is not subject to civil service, as set forth in 714.1. It specifically accepts him from the Civil Service Code. It says, the following shall apply except for Chief Deputy, and then it enumerates that. It's an employment section of the code. It's not related to candidacy. It's not related to the Constitution that provides for the minimum requirements in order to be a candidate on the ballot. None of those things are addressed. It's a purely employment-related issue. He is exempt from that. Therefore, inasmuch as the entirety of the case is based upon a violation of 714.15, and this court has said, you're not hearing anything about the Hatch Act today, inasmuch as the entirety of the case is based on that, it should be dismissed because he is exempt entirely from that statute. Additionally, we would add, intervening since the filing of that motion to dismiss, Mr. Kelly has withdrawn his name from the ballot. He has filed that with the county clerk. We have followed up and provided a copy of that document with a letter to the State Election Commission pursuant to the code that we believe is relevant and controls here. And therefore, the entirety of this proceeding is mooted by that activity. So for those reasons, I would ask that this matter be dismissed, and there's no need for any further hearing.
Mr. Crooks, would you like to respond to that?
Yes, sir. First, Your Honor, I would want to state for the record in respect to the objection that Mr. Hartman articulated in respect to service of our brief in opposition to his motion to dismiss. The court file will demonstrate that attached to our brief is a certificate of service I signed on July 12, 2012, certifying that a copy was mailed to Mr. Hartman. If it got lost in the mail, I had no way to know it. If it got lost once it entered the document management process at Mr. Hartman's office, I would have no way to know. Mr. Hartman likewise has stated that he does in fact have a copy of our brief. He has read it. He is not unfairly prejudiced by the service of our brief on July 12, 2012 in opposition to his motion to dismiss. That's the first thing. Secondly, I can agree with a couple of things that Mr. Hartman said. This is an objection that they raise under the civil service statutes. That does not apply to this case. This is an election challenge, and the election challenge turns upon Chief Deputy Kelly's eligibility to stand for election on May the 8th, 2012. He was in fact ineligible, and my presentation on the merits of our case today will make plain that he was ineligible to stand for election on May the 8th. And the reason is found in West Virginia Code, Chapter 7, Article 14, Section 15, Subpart A, Subpart 4, which very plainly states that any deputy sheriff that is subject to the provisions of 5 USC Section 1501 et sec, that's the Hatch Act, may not be a candidate for elective office. Now, we're not here today as a civil service board. This is not a civil service case. This is an election challenge. I understand the Commission's position with respect to litigating whether Chief Deputy Kelly violated the Hatch Act. But the fact is, we don't need to go that far. Under West Virginia Code that I've just quoted to this court, it is the fact that Chief Deputy Kelly was a deputy sheriff who was subject to the provisions of the Hatch Act. West Virginia Code does not require that we prove a violation of the Hatch Act occurred. Does not require. All it requires is that the evidence show that Chief Deputy Kelly was subject to the Hatch Act. Now, I understand Mr. Hartman's strategy of bowing out in the face of the ultimatum letter that his client received from the Office of Special Counsel in charge of enforcing the Hatch Act. He didn't have very many options. One was to stand and fight the allegations leveled against him by the federal lawyers who enforce the Hatch Act. He didn't want to do that because he would lose. And in so losing, he would also cost Upshur County funding under federal programs. Second, he could stop his ongoing violation of the Hatch Act by leaving the position that he held with the sheriff's office. This was attempted last week by the current sheriff who came before this body and asked that Chief Deputy Kelly be reassigned to a new position. That effort was unsuccessful, largely because that effort was an obvious strategy connected to this election challenge. Even if Chief Deputy Kelly was successful in being reappointed to a different job such that he would terminate his ongoing violation of the Hatch Act, he would still have to face this election challenge. Because as this court has already demonstrated at the outset of these proceedings today, we have two separate issues. One being a federal question prosecuted by the special counsel under the Hatch Act. That is not our purpose here today either. We're not here to sit in judgment of a Hatch Act case. But the second point is the election challenge. Was Chief Deputy Kelly eligible to stand for election on May the 8th? He was not. The only body with jurisdiction to render a decision on the Hatch Act and whether it was violated resides at the federal level. The federal prosecutor, the special counsel, clearly was prepared to bring a case and prove a violation of the Hatch Act. Again, and I'm sorry to run a lap on this point, but it's so important.
Well, I'm just going to state my objection for the record.
I object to being interrupted.
If we're not talking about the Hatch Act, we're spending a lot of time talking about the Hatch Act. Move on.
We'll let you respond in a second.
I'm responding to his attempted motion to dismiss. And there's no way to respond to that on the merits without making reference to the Hatch Act to the extent that I have. And to the extent that I've been talking about the Hatch Act, what have I been saying? That we're not here to sit in judgment of a Hatch Act violation. That's all I'm saying. We don't have to. The extent to which the Hatch Act bears on these proceedings today is found in the language that I've already read into the record under 714.15 subparagraph A, subparagraph 4, which says that any deputy sheriff that is subject to the provisions of the Hatch Act may not be a candidate for elected office. That's all we have to show, is that he was subject to the Hatch Act. So, having said that, I turn to the second point that Mr. Hartman raises, which is that Chief Deputy Kelly has withdrawn from the election, therefore this case is moot. He is wrong. He is wrong, and this will be a central feature to our case on the merits, in the sense that Mr. Hartman has consistently, through statements in the media and comments to the support staff for this county commission, stated incorrectly that the provisions under Chapter 3, Article 5, Section 19 of the West Virginia Code are activated because of Chief Deputy Kelly's decision to withdraw from the election. He is incorrect on the law on that point. In fact, I would submit that it is objectionable that he should portray that position out of court to the administrator for this body, such that it results in an article such as we see in today's copy of the record Delta. The headline to the article says, "County unlikely to name Taylor sheriff-elect." He's tried to predispose this body with statements to the media that are incorrect on the law. Fact is, what we have done, my client and I, we have filed an election challenge under Chapter 3, Article 6, Section 7 of the Code. Section 6 and 7 of the Code. Jurisdiction is vested under Section 6. And again, I'm fully prepared to lay it out very completely and accurately as to why this county commission is sitting as judge of the primary election. That's why you may have noticed in my address to this body, I refer to you as your honors in this court, because the West Virginia Code very plainly and specifically says that you are sitting as judges. This is a court, and you're sitting in judgment on the May 8th election. This is not a situation where we are finding ourselves under 315.19 post-election, no timely challenge having been filed, only one candidate on the ballot develops an illness or dies or is determined to be ineligible for some reason, and suddenly there's a vacancy on the ballot. And the only thing to do is to have the county Republican committee appoint someone to fill the vacancy. That does not apply in this case. This is the case, the jurisdiction is in this body as a court judging the election, and there is no vacancy in nomination. And that is the critical terminology that shows the fatal weakness in the argument Mr. Hartman has tried to make. In fact, there is Supreme Court precedent that defines what vacancy in nomination means. And it means, in very simple terms, that the candidate on the ballot has withdrawn and there are no other eligible qualified candidates to take that person's place. That's clearly not the case here. We filed a timely election challenge, and the result of the May 8th primary election is not final. It's under challenge, and it won't be final until this body, sitting as judge of the election, hears all the evidence and makes a determination and declares the true result of the election. And our evidence will demonstrate that David Taylor, my client, polled more votes than any other eligible candidate in the field. The fact that Chief Deputy Kelly ran illegally at the time and garnered more votes is of no legal consequence. He was ineligible. Politics is often analogized to a horse race. That horse got scratched. Ladies and gentlemen, hold your tickets. That horse should not have been on the track. So, what was the true result of the May 8th primary election? The true result was that David Taylor garnered more votes than any other eligible candidate in the field. He won the election. That's the point of this case here today. The fact that Chief Deputy Kelly has bowed to the inevitable and sought to avoid prosecution at the hands of the Office of Special Counsel or lose his position entirely is of no legal consequence to the fact that we have filed a timely, valid election challenge under West Virginia Code. Chief Deputy Kelly is out of this race. He's out of this case. In fact, I object to Mr. Hartman even having the opportunity to make arguments and present a case of any kind in opposition to our petition challenge here today. I was provided only this morning a copy of Mr. Hartman's letter dated July 16, 2012. I intend to offer this into evidence in the course of my case after I double check the record on this, because it may already have been recited as part of our record, but I don't want to diverge too long onto a procedural technical issue. At any rate, I was provided today Mr. Hartman's letter of July 16, 2012, addressed to the State Election Commission of West Virginia, stating that he was writing on behalf of Michael Kelly, and he was submitting an attached notice of withdrawal of candidacy, which I still have not seen. I object to that. He is giving notice that his client is withdrawing from the election of sheriff of Upshur County, and he wishes to have his name removed from the general election ballot. Mr. Kelly's withdrawal, he goes on to say, it's based on personal reasons related to his wife's health. Pardon me. The reasons are immaterial. The fact is he was ineligible under the West Virginia Code, as I've already said. It is not an intent statute. It doesn't say anything in the statute about if you intentionally violate the Hatch Act, you're ineligible. It just says if you're subject to the Hatch Act, you may not run. So, you know, he can say that he's withdrawing because of his wife's illness. I have no independent information in that respect. I don't necessarily doubt that she has a health problem, and for that I am sorry, but it's of no legal consequence to this election challenge, this petition. He's out of the race. He's taken himself out of it for whatever his reason. And, you know, therefore, he has no more standing in this case. His lawyer has no legal right to even stand up and make a motion to dismiss this case. Are there any questions as to respect our position in opposition to this motion to dismiss, Your Honors?
No, would you like to respond, Mr. Hartman?
If I may, I'd be fine not to be here, to be honest. I was going to play golf today because I had it on my schedule. We were going to be here. I thought this was off. I had golf scheduled. I'm no longer playing golf, so I'd be fine not to be here, quite honestly. And I think we are out of this case, and that's precisely why you guys can't move forward. It's very convenient for Mr. Crooks to want to advance a petition but have nobody dare respond to it or defend it or oppose anything he has to say. That would be very convenient. I'm sure it would go a lot faster. But that's not how it's done. If the election challenge, if he at one side of his mouth says the election challenge is still pending and we still have to go forward, then we have a right to be here. The reality is, though, well, let me back up for a second. The other thing I'm just really candidly tired of is this idea that Mr. Kelly has bowed to the inevitable, that he saw the writing on the wall and there was no way he could possibly win this case. I would love to have this election challenge. It's one of the few times as a lawyer that I've actually thought I'm right about something and been pretty damn well convinced of it going into this court. I'm pretty comfortable with having this election challenge if this body wants to, because I believe we're right. And if this body doesn't get it right, I'm confident the circuit court will. I believe the law and the facts are on our favor. Mr. Taylor can't get what he wants. He wants to just undo the election. He wants you guys to pretend that this election never happened. He's filed a meritless petition asking for a remedy that doesn't even exist in law to put the second place winner in there. That doesn't happen where we are in the process. That is not a remedy that can even occur. If you don't believe anything out of my mouth today on the law or why Mr. Kelly will prevail or why you can't even hear this case because it doesn't apply to him, that's fine. But the reality of the law is that 3519 does control this case. That even if you found Mr. Kelly disqualified, let's just say you say Hatch Act disqualifies him, can't be a candidate, he still doesn't get what he wants. There's no provision under the law. It goes back to either the state election committee and then the Republican committee here in the county, or it goes directly to the Republican committee if you find him to be ineligible. Either way, you don't give Mr. Kelly what he wants. And that's the frustrating part of this whole procedure, is that we've spent months and thousands of dollars and all kinds of time on this folly, on this pure arrogance of this petition when he doesn't even get what he wants. And we've wasted the county's time and the county's dollar, and we've ignored the will of the people 2-1. Not a single precinct was won by Mr. Taylor. Those things are all forgotten in this process somehow. And I don't think they should be. You can't hear this case because the law doesn't, it's a civil service code that doesn't apply to the eligibility on a ballot. The Sowards case clearly sets forth that. And even though the statute has changed since the Sowards case, 10 years after the Sowards case, I might add, not like the following legislative session as a result of this landmark case by the Supreme Court, that the following session they went up and tidied it up, as is commonly done in the legislature. 10 years later, the statute changed. So I don't think the two events are related. But even though the statute has changed, the constitutional principle still applies. You can't deny the ballot access to Mr. Kelly. You can't deny the citizens of Upshur County the right to vote for whom they want. What you can do is fire him, I suppose. It's an employment issue. It's an employment issue, not an election issue, and the statute doesn't even apply to Mr. Kelly. You can't hear this case.
May I have a reply to that?
You can reply.
Thank you. Fact is, if there's anybody trying to argue both sides of an issue, it's Mr. Hartman. He wants to say that this case is now moot and cannot go forward because his client has withdrawn from the election. At the same time, he wants to say that that's not material. Fact is, it is material only insofar as it takes out of play part of the purpose of our petition. Our petition, Your Honors, is not directed against Chief Deputy Kelly. And right in that point, right there, resides the fundamental departure that Mr. Hartman takes from the law that applies to this case. He's trying to convince you and the media and the citizens of Upshur County that this is all about his client. It's not. And I will demonstrate in the course of our case on the merits that the statute we have invoked here invests jurisdiction solely in the county commission sitting as a judge of this election, the May 8th election. Okay. Our petition is directed at correcting the defect that occurred in the May 8 election. It's not directed at Chief Deputy Kelly. He is free to go. In fact, I would request that he do so, because his presence here and his lawyer's participation in this case is against the law. Why is it against the law? Because he has no further interest in this case. He has no standing. That's the legal term. He has no standing. He has no interest in the outcome of this, other than whatever publicity this litigation may generate for his lawyer and whatever public sympathy that Chief Deputy Kelly might garner in the process. So that is why I object to his participation in this. Our petition is directed to the defect that occurred in the May 8 election. That defect was an ineligible candidate being on the ballot. We are well within well-established statutory law here for this commission to sit as an election court under Chapter 3, Article 6, Section 6 and 7, and judge the merits of our petition that bring before this court the defect in the election, an ineligible candidate. That ineligible candidate has now taken himself off the ballot. So that much of our petition is resolved. I need not technically demonstrate his ineligibility, because if there's anything moot, that's the point that's moot. He's out of the race now. That doesn't mean that our petition's over. We still have to cure the defect in that May 8 election. That final result is suspended pending the judgment of this county commission sitting as an election court. And I'm prepared to take the court through our evidence and through the law that applies. This case, I can agree with Mr. Hartman to the extent that this case has nothing more to do with Chief Deputy Kelly. I'm the president of the Pines Country Club. If it would help Mr. Hartman, I'd be happy to take a 5-minute recess, call ahead, and arrange a tea time for him at the club a couple hours from now. He has nothing further. He has nothing further to say about this case. Thank you.
Okay. We will adjourn briefly for deliberation on the facts presented to us at this time.
Yes.
Okay, the general consensus of the commission is to take the objections under advisement Both parties are entitled to participate, and the commission will continue with the hearing. Are there any objections to that with my fellow judges? If not, then we will continue with the testimony at this time.
Thank you, Your Honor. May it please the court. I have some prepared remarks. I've got some exhibits that I'm going to offer into the evidence. And then I want to conclude with an argument on the law. First, I would like to start with some facts that are established beyond any contest. Most of the facts that are foundation to our case were admitted in the response that was filed in this case. If Your Honors look to the response that Chief Deputy Kelly's attorney filed, it's admitted that since January of 2005, Michael R. Kelly served as the Chief Deputy for the Upshur County Sheriff's Department. Secondly, it's been admitted that Chief Deputy Kelly, in his official capacity, administered several federally funded public safety programs. And in fact, part of his compensation as Chief Deputy was received from these federal funds flowing into Upshur County. I would suggest to Your Honors that many of the exhibits that we are going to offer into the record today have been obtained by way of Freedom of Information Act request from governmental bodies at principally the state and in some cases the federal level. Under the rules of evidence, those documents are self-authenticating because they come from a governmental source. They are deemed and presumed to be authentic and beyond any challenge as to their authenticity. Of course, their relevance will be made plain in the course of our presentation here. What these exhibits...
I apologize for the interruption, but I'm attempting to save this court and Mr. Crook some time. We had originally scheduled a pre-hearing meeting. I'm willing to stipulate to several of the facts. I think the facts are, generally speaking, not in dispute. It's just your application of the law that is fundamentally in dispute, what would sort of be a summary judgment motion that we're both filing cross-summary judgment motions. So inasmuch as there's no need to introduce that evidence or we'll waive it through, there's no objection as to the fact that Mr. Kelly was the chief deputy and there's no doubt that the grant funds came through. We don't object to any of that stuff. We just think even if whatever he says is true, we just don't think he gets what he wants. So inasmuch as we're willing to stipulate to many of the facts, I thought we could save this body some time on not going through a great deal of evidence.
While I appreciate the offer to waive objection and stipulate in the admission of our exhibits, and that will save some time, I would submit to Your Honors that, as Mr. Hartman himself has pointed out, the parties have expended considerable resources of their own in preparing this matter for today's presentation. The material that I have to go through probably won't take much longer than Mr. Hartman's objection and my response to it is taking right now. And more than that, there's been so much inaccurate information given to the public media and reported that I think it important that not only for Your Honors sitting as judge of this election that you indulge my method here and the full recital of the evidence. But I think it's also important for members of the media and members of the public at large who have taken time out of their day to come here and hear this matter. So
we'll overrule the objection and try to be as timely as possible.
Yes, sir. Economy will be my hallmark.
Okay, very good.
All right. I've already established that since January 2005, Chief Deputy Kelly has served in that capacity, and in so doing, he administered federally funded programs. Why is that important? Because it demonstrates that he's subject to the Hatch Act. And again, I'm not trying to go beyond that and prove, you know, the sort of case that the OSC would be charged with proving to another body. I'm simply establishing a legal predicate necessary for our case as stated in our petition. He is subject to the Hatch Act. January 11, 2012, Chief Deputy Kelly filed as a Republican Party candidate for the office of Sheriff, Upshur County, West Virginia. Your petitioner, David D. Taylor, is a resident of Upshur County, born and raised. And he was one of 3 candidates on the May 8, 2012 Republican Party primary for the office of Upshur County Sheriff. 3 candidates on the ballot. As I will proceed to demonstrate, only 2 of those 3 candidates were eligible to be on that ballot. On May the 18th, the Upshur County Commission certified Michael R. Kelly as the winner of the May 8 primary based on his receiving approximately 63% of the ballots cast. And I've heard that in these proceedings today. I've read it multiple times in the media, what the margin on behalf of Chief Deputy Kelly was in the primary election. I would submit to your honors that this is one of the purposes of the Hatch Act. Someone who is in a position such as Chief Deputy Kelly, administering all these very worthwhile public safety programs, such as are identified in the various exhibits that we're going to submit under stipulation. That role as administrator of those very worthwhile programs engenders a lot of public goodwill. Why wouldn't it? Look at all the good that these programs do. And the man who stands out front in his uniform and gets his picture in the paper in association with all the good effort that's being put in through these programs scores a lot of goodwill with the public in the course of it. And that's why the Hatch Act does not permit that same person to trade upon all that goodwill that they've engendered, in part using federal tax dollars, to then run for public office. That's the point. So, May the 18th, this county commission certified the result. Then David Taylor filed his election challenge petition on May the 25th. And this was filed pursuant to West Virginia Code 3-7-6. I may have misspoke a little earlier in my remarks opposing the motion to dismiss and may have misquoted the code section. In so doing, I hope I didn't throw us too far off the proper path here. But the code section that we have invoked with our petition, let there be no mistake about it, is West Virginia Code Chapter 3, Article 7, Section 6. And what I have done in filing that petition is I have pointed out the provision that I quoted to your honors in opposition to Mr. Hartman's motion to dismiss. The provisions stated in Chapter 7, Article 14, Section 15, Subpart A4, provided that any deputy sheriff that is subject to the provisions of the Hatch Act may not be a candidate for elective office. Now, Mr. Hartman wants to suggest that that doesn't apply here because that's part of the Civil Service Code. Well, it may be found in that part of the code, but what it amounts to is an ineligibility for public office. And the counsel who is assisting your honors will tell you that it is a time-honored tradition and practice of the law that statutes, public law, have to be read in harmony with each other, not in separate, discrete boxes such that they don't have any interrelationship and no harmony. That's not how it works. Statutes have to be read in harmony with one another so that they don't do violence with each other, and that the law is steady, it is predictable, it is understandable, and it can be followed. So, in our petition timely filed May the 25th, we cited to West Virginia Code, Chapter 7, Article 14, Section 15, Subparts A4, citing Chief Deputy Kelly's ineligibility to be on the ballot. May the 31st, Chief Deputy Kelly, through his attorney, filed an opposition to our petition and the motion to dismiss, which you have taken under advisement. In the course of their argument, they took the position that they implicitly admitted there was a violation of the Hatch Act, but what they argued was that it was not a knowing violation. It was not an intentional violation of the law. And then they went on to argue the provisions that used to be found in Chapter 7, Article 14, Section 15, and they argued that this was a mere technical violation. And in doing that, what they were trying to do was they were trying to mount an argument under a statute that doesn't exist anymore. It's been substantially rewritten in 2007. And they also sought to invoke the Sowers case, which you heard Mr. Hartman speak to. That case interpreted the old statute. And essentially what it said, what the Supreme Court of our state said in reviewing the old statute was that it was too vague. It needed to be more specific and more clear in its statement, so that someone who aspires to public service and wants to stand for an election, will know without any doubt whether they're permitted to do it under the statute. So 2007, the statute was in fact amended to the language that we have cited in our petition. The fact that it took 10 years for the legislature to get around to it, I'm not too sure, why that was, a cogent point to this. It is the law. The statute was rewritten. It is clear now. And it says unequivocally that any deputy sheriff covered by the Hatch Act may not be a candidate or hold other public office in the county. Very clear. Now, like I said, in the response to our petition, that was their first line argument. Superseded statute, an old case decision construing a statute that doesn't exist anymore. And in respect to the idea that the violation was not a knowing violation, it's a very simple response to that, which we've stated in our opposition brief that's in the court record. Intention is not part of the statute. The statute says nothing about violation of the Hatch Act. It doesn't say anything about a knowing violation of the Hatch Act. It just says that if you're subject to the Hatch Act, you're ineligible to run for elected office, period. So all this argument about knowing violation and mere technical violations and arguments under an old statute and an old Supreme Court case construing a statute that doesn't exist anymore is all beside the point. June the 21st, 2012, the United States Office of Special Counsel, federal executive branch agency with the exclusive jurisdiction over the Hatch Act, sent a letter to Mr. Kelly. Told him that in their judgment, he was in violation of the Hatch Act and it was an ongoing violation. He had to do something. He stated an ultimatum. Resign your position and carry on in the election if you can. They expressed no opinion with respect to this case. He would still have to confront this election challenge had he opted for that approach. And in a fashion, he tried to get there. The current sheriff appeared before this body last week, Your Honors will recall, in an effort to gain an appointment from this body for Chief Deputy Kelly to a position that, in the current sheriff's opinion, would not be subject to the Hatch Act. That approach was obviously linked to this litigation, and the letter from the Federal Office of Special Counsel, it was unsuccessful. Ultimately, we know that Chief Deputy Kelly elected then to do the only other option that was suggested to him by the Office of Special Counsel. That is, he withdrew from the election. Likewise, when I tender my exhibits, I intend to offer the letter of July 16, 2012 from Mr. Hartman as counsel for Chief Deputy Kelly, addressed to the State Election Commission. And as I've said, and I won't go back through the whole argument, for that reason, Chief Deputy Kelly has no further standing in the case. And that's why I objected to his lawyer's continued participation in the case. I understand your ruling, and I'm not arguing with it, but that's where we are. One second. As I said before, but I will repeat this one point because of its importance. The Office of Special Counsel, in their letter of June 21, only addressed the Hatch Act. And they did not address the proceedings that we are together about here today. They expressed no opinion about our election petition. Nowhere in that letter did they say that by withdrawing from the race that Chief Deputy Kelly would render our petition moot and that this body would lose its jurisdiction and would have to dismiss the petition. Nothing of that sort appears anywhere in that letter from the Office of Special Counsel. They have respected your jurisdiction and left you to the job that the West Virginia Code brings to you. I have this letter of July 16, 2012. I obtained a copy from Mr. Hartman before we started this morning. I do not yet have a copy of the official notice that was sent to the Election Commission.
Downstairs in the clerk's office. There's a copy.
All right, thank you. Let the record show Mr. Hartman has kindly provided me a copy of the notice of withdrawal of candidacy. Thank you, Mr. Hartman. I intend to proffer that right along with Mr. Hartman's transmittal letter as an exhibit into evidence in this case. At this point, I think it would probably be appropriate from a procedural perspective for me to go ahead and tender our exhibits. What I have done, Your Honors, is I have put my staff at the office to the task of copying up all of the exhibits and placing them in a tabulated format. Mr. Parker? Thank you, sir. Your Honors, after the compilation that you all now have was prepared by my staff, it came to my attention that I had left something out. So I also want to tender that. Mr. Parker, copy for you. Your Honors, this additional exhibit is captioned West Virginia Governor's Highway Safety Grant Program. And again, these are all documents that we have obtained by way of Freedom of Information Act, save for one exception, and that is a copy of the letter from the Office of Special Counsel addressed to Chief Deputy Kelly, and that copy I obtained from Mr. Hartman. Let's see. The last exhibit I have to offer is a joint exhibit, and it would be the same July 16, 2012 letter from Mr. Hartman addressed to the State Election Commission of West Virginia, care of Natalie Tennant, along with the referenced enclosure, which is a State of West Virginia notice of withdrawal of candidacy form, signed and filed on behalf of Chief Deputy Kelly. I've only been provided these documents before and during this proceeding, so I have not been in a position to make multiple copies of this. I would simply ask that Mr. Parker please enumerate the Governor's Highway Safety Program exhibit as well as this last joint exhibit in sequence in line with the tabulated exhibits that have already been supplied. It's my understanding that Mr. Hartman is prepared to waive objection and stipulate the admission of all these exhibits.
It's not exactly true anymore. Inasmuch as his staff is significantly bigger than my staff, evidently. The objection that I have is that this seems to be, and it was part of his petition, and cumulative to grant years 2009, 2010, 2011, none of which are relevant for this particular proceeding. If the allegation is that a violation occurs of West Virginia 7-14-15 upon Mr. Kelly's filing of his candidacy, the only period that is relevant is the date when those two incidents collide, that he is both a chief deputy and he is now a candidate. So only the grants from January 11th onward are the only ones that matter, they're the only ones that count, and they're the only ones that this body can consider. It doesn't mean a hill of beans what happened to a grant in 2009. It really doesn't. Doesn't have any relevancy at all. And it's sort of a stunt to put it in this kind of volume, to plunk it down on your table, and to make it look like something nefarious has gone on, or that there are thousands and thousands and thousands and thousands of dollars at stake. That's simply not the case. It's theatrical, it's unnecessary, and largely legally irrelevant, and you can't take a look at it except for January 11th to present. Those are the only grants that matter.
I'll make no apology for the fact that I have a staff that assists me, and they do a very fine job of it too. In fact, I'm quite proud of the fact that I'm a partner in a law firm that is capable of taking on a task such as this and handling it in the way that we have. I have nothing to apologize for there. As far as it being a stunt is concerned, I don't know what else to say except that it's just not true. This is a customary approach to submitting large numbers of exhibits in court proceedings, and that's all I've done. I don't really hear much of an argument in the objection as against the substance of the evidence, except for the argument that all these documents have to be dated at or after the date on which Chief Deputy Kelly filed for office. That's not true. The fact is the statute that we invoke in our petition, 7-14-15 subpart A4, simply says if you are subject to the Hatch Act, you are ineligible to run for public office. Now, in this case, the exhibits that we have submitted demonstrate that federal funds were flowing into Upshur County and funding many programs administered by the Sheriff's Office. And it is, I'm sure, a point that is well known to your honors. Being you're sitting as an election court at the moment, but I mean the reality is you're also the county commission, and you're all very familiar with the flow of funds into the county and the fact that part of that money comes from federal grants. So the fact is this money comes into the county. It brings with it Hatch Act application. The flow of federal funds into this county brings with it Hatch Act application, and it's been demonstrated already and admitted that Chief Deputy Kelly, since 2005, has served as the Chief Deputy and has administered many of these programs, and in fact part of his compensation has been underwritten by federal tax dollars. So that is the point of our submitting these documents, to object to them, to say that they are irrelevant because they aren't dated on or after February 11 when Chief Deputy Kelly applied to run in the primary election is simply incorrect and beside the point.
Mr. Hart.
It's an objection about the legal relevancy of these documents. They're not. Any grant funding prior to the date of his filing is immaterial. I'm preserving the objection should there be an appeal. I'm stating it on the record. Okay. Secondly, I want to make sure that we're clear about this. Chief Deputy Kelly did not administer a single grant of any kind. He is not a grant administrator. He does not sit on top of those. The Sheriff Miller does and Deputy Rowlandson does. So it's inaccurate to say he administered it. That's not it at all. That's not his role. We can get into that as the evidence goes, but it's factually incorrect.
Okay. We'll take the matter under advisement and then just mark and enter the documents.
Thank you.
Mr. President, the documents 1 through 9 will be petitioner hearing exhibits 1 through 9. Document 10, petitioner's hearing exhibit 10 is the highway grant memo, and 11 is the July 16 letter.
As well as the document that was transmitted by it.
Yes, sir. July 16 letter and transmittal.
Thank you. All right, Your Honors, at this point, I move to the mode of presenting our case under the law. Wish I had enough for everybody. Your Honors, let me do it this way. Let me hand these up to Mr. Parker. Mr. Parker, I want to give you 3 of these for the judges, and let me give you another one for yourself. Your Honors, what you have in front of you right now is my way of showing you the law that I am arguing by way of our election challenge in this petition action. What I have done here, so that you understand and have no concern about the authenticity of what you're looking at, I simply went on the web, the internet, to the state website that has the code available, and I copied and pasted from the internet and just pasted it into a document on my computer, and I even blew up the font size, because if Your Honors are anything like me, it makes it a lot easier when you read something in at least 13-point font. But other than that, the only differences that you'll see in this text from the West Virginia Code will be areas that I have highlighted, and of course that's simply for purpose of directing attention and giving emphasis to my argument. And in a couple of instances, I have used bold type font, and again, that's simply for the purpose of directing one's attention and giving emphasis to the legal point that I'm arguing. In fact, Your Honors, what you have in front of you are 2 sections of the West Virginia Code in their entirety. The first is West Virginia Code, Chapter 3, Article 7, Section 6. 3-7-6. And this is captioned County and District Contests, Notices in Time. Your Honors will note that the language in this statute was updated as recently as 2002, so that it's using a more modern verbiage. It's not using an arcane, older style of language that you may still find in some of the sections of the code. The language is very clear. At the beginning, the very beginning, first sentence of 3-7-6 says, and I'm just quoting from the law, in all cases of contested elections, the county commission shall be the judge of the election, qualifications and returns of their own members and of all county and district officers. All right, there's a proviso that follows, but it doesn't pertain to our case here today. Now, I have highlighted some language in that first sentence. First highlight is all cases of contested elections. Point is, there is no doubt that this petition that we have filed challenging the primary election result is covered by this statute. I harbored some little concern that perhaps there might be a question raised. Perhaps this statute only applies to a general election, for instance, and not to a special election or to a primary election. Well, that's not the case. Firstly, in answer to that question, should it be raised, I simply point back to the language of the statute, which says, in all cases of contested elections. It doesn't say, in all cases of contested general elections, thereby raising the implication that it doesn't apply to a primary. It doesn't say, in all cases of general and special elections, implying that it doesn't apply to primary. It just says, in all cases of contested elections. Likewise, Your Honors, I would hasten to tell you that the West Virginia Supreme Court of Appeals, in the case of Miller versus County Commission of Boone County, legal counsel for the commission can supply you a copy of that if you care to see it, held specifically that West Virginia Code 3-7-6 does apply to primary petitions. So let there be no doubt. This code section applies to all contested elections. Not some, but all. All right. The next highlight I have is the language that says, shall be the judge of the election. This was the point I spoke to early on in this proceeding today. You are sitting as a court. You are judges of the election. You're not judging Chief Deputy Kelly. You're not judging David Taylor. You're judging the process and result of the primary election conducted May the 8th, 2012. That is what is before this judicial body today. Was that election validly conducted in all respects? Our petition stands to say that it was not. And the only aspect of that May 8th election that we challenge in our petition is the eligibility of one of the candidates. That's it. We're not contesting ballots. We're not contesting the process by which the polls were opened and closed. We're not contesting any of those things. We are merely focused on one point, and that is the eligibility of one of the candidates to be on that ballot. And that question is part of the case that we have to present here. That is the issue that was resolved essentially by Chief Deputy Kelly's decision to withdraw as a candidate in this case. Like I said before in response to the motion to dismiss, that does not end this case. Because it says in the code, and I proceed on now in the second paragraph of 3-7-6, if you'll follow with me, you'll see that that the petition has to be filed within 10 days of the result of the election certification being issued. Certification in this case was issued by the County Commission on May the 18th. So under the code, you start counting 10 days, the 19th being the first day. We filed our petition on May the 25th, well within the 10-day period. So our petition is timely filed under Section 6, that is to say, Chapter 3, Article 7, Section 6. In this same second paragraph, you'll see where I have highlighted language that says, if the contestant, that would be David Taylor in this case, objects to the qualification of the person returned as elected, which is what he has done, the notice shall set forth the facts on which such objection is founded. And that is what we have stated in our petition. That is what has been substantially admitted in the response that was filed. All the facts that Mr. Hartman did not want me to recite into the record earlier in this proceeding. Those are in our petition. That petition was timely filed. It was supported by an affidavit executed by David Taylor. the provision that applies to procedure in this case is found in 3-7-7. And that is the second provision you find copied and pasted into the document that I distributed. I probably should have highlighted a little bit more language in Section 7. And particularly in that respect, I'm thinking of the very first sentence. The county court. Now notice the term county court is used there. And in that respect, I would point out to you that the last revision of 3-7-7 was in 1963. That was before things were reorganized around the state. And I believe in those days, county commissions were county courts. So at any rate, you don't have any concern because when it makes reference to the county court there, what it's talking about is the county commission. And the lawyer counseling your honors, will verify that point. I have no doubt about that. It's very, very clear in the printed volume of the West Virginia Code and in the annotations that appear in the printed volume of the code. So 3-7-7 is speaking of the county commission. The county commission shall. There's that word again, shall. I've been using bold font and highlighting to point out all the places in these provisions of the code. I do that for a very particular reason because under the law there are two forms that are used in statutory provisions, may and shall. May obviously means that the officer or body charged with a duty has discretion. In the instance of shall,
I just insert, not necessarily an objection, but I concede to this court's jurisdiction to hear an election contest, and I don't know that that's an issue in dispute. So
it is an issue in dispute. Read any article that has run in the paper concerning this case, and you'll see Mr. Hartman quoted as saying that his client's withdrawal from the election means that this petition action is at an end because Chapter 3, Article 5, Section 19 says that when a vacancy and nomination occurs, the State Election Commission has to accept the withdrawal and then refer the matter to the County Republican Executive Committee so they can appoint someone. That is the argument that he has been peddling to the media right along through the pendency of this case, and that is the argument he's tried to make here in front of your honors today. It is wrong. And why is it wrong? Because of exactly what I'm going through right here.
I must overrule. Continue.
All right, thank you. So, as I was saying, in statutory language, when the word may is used, it very clearly means that the body or officer charged with a duty under the law has discretion in how they execute that duty. When the word shall is used, that is a mandatory term, and that means there is no discretion permitted. It is a mandatory duty, shall. And that's the language we see appear in both 3-7-6 as well as 3-7-7. And so, it says in 3-7-7 that the notice of contest shall be presented to the county commission. You see in the code they even put county commission inside brackets to demonstrate who they're talking about. At its first term after the same is delivered to the person whose election is contested, and the same shall be docketed for trial in such court. And that's what we're having today, a trial. Now, further on in 3-7-7, I've highlighted and bold typed some additional language. At the final trial of the contest, the county commission, sitting as a court on the election, shall, there's that word again, shall, mandatory directive from the legislature to this body, declare the true result. The county commission, sitting as an election court, shall declare the true result of the election and cause the same to be entered on the records of the court. So, that is the purpose of our petition, is to challenge a defect in the election that was conducted May the 8th. We've done that. We've resolved that problem to the extent that the ineligible candidate that we challenged has withdrawn from the race. And now it is for this body sitting as a judge of the election. And that's the language that you will find in 3-7-6, the first section we started with. Go back to the first sentence of that section. It says, in all cases of contested elections, the county commission shall be the judge of the election. That is mandatory language directing this body to sit as a judicial body and judge the election, not judge individuals who participated in the election. Well, yes, to judge individuals who participated in the election insofar as their eligibility may be at issue, but that's now resolved, we know. But to judge the result of the election and determine whether that certification that was issued on May the 18th needs to be corrected. You know, I analogize it to, let's say, a football game. You know, we all see football games on TV where it looks like someone caught a pass for a touchdown in the end zone, and one of the coaches thinks that maybe they had stepped out of bounds, and he throws a little red flag, and everything stops. You know, the case is under review. Everybody in that stadium knows that that touchdown may be invalid. And they wait for the review upstairs in the booth, as they say. And sometimes they say, we don't see any basis to disturb the call on the field. Sometimes they say, no, he was out of bounds. That's not a touchdown. Another analogy that I think I've used already in the course of these proceedings today would be a horse race, which may be a little more appropriate analogy given this is a political, an election. People often analogize elections to horse races. You know, anyone who's ever gone to a horse race and you know, placed a couple of dollars on a horse knows that it's quite possible that once the horses cross the line, sometimes the announcer will say, hold your tickets please. And if a horse has been disqualified, the first horse across the line isn't necessarily the winner. They accord it to the next horse that crossed the line. So, procedurally speaking, that's where we are here. We have suspended the final certification of the May 8th election. Now, I would say this as well. What we are talking about here under 3-6, I'm sorry, did I go again? What we're talking about under 3-7-6 and 3-7-7 is a jurisdictional issue. Now, jurisdiction is a very fundamental, compelling concept in the law. It just means that who has the power, who has the duty, the responsibility to take action. And in this respect, 3-7-6 is investing the county commission with jurisdiction. You and no one else have the authority to sit in judgment of the elections conducted in this county. You cannot decline to act on that responsibility. It says you shall be the judge, and you shall declare the true result of the election. So simply declining or refusing to act is not an option. In fact, you cannot delegate your responsibility. This code provision will not permit the county commission to punt this issue to the State Election Commission or the Upshur County Republican Executive Committee. Now, I know that Mr. Hartman has repeatedly argued to the media and has suggested to Mr. Parker and to Mr. Stranko that this is all taken care of under 3519. He's wrong. Fact is, that provision of the code is talking about situations where you have but one candidate in nomination. One candidate. And that person, for whatever reason, they die, they become sick, somebody goes to the election commission about them, rather than coming before the county commission within 10 days. Instead, they go to the state election commission sometime later and point out that the one candidate in nomination is ineligible. And in those instances, where you have nobody else to put in that position, what are you going to do? You're going to leave the office stand vacant? No. The code provides that in those instances, the county executive committee for the relevant political party can appoint someone. Now, I would hasten at this point to tell you of a case that was decided by the West Virginia Supreme Court of Appeals. That case is called Tillis, T-I-L-L-I-S versus Wright, W-R-I-G-H-T. Your Honors, that case was decided July 7, 2005. And it's a kind of a lengthy decision. There's a lot of procedural history involved in it, and that's really not the point of my bringing it to you. I know, we're trying to get through this in an economic fashion. So let me cut to the chase for why I offer this decision. In that case, the state Supreme Court was examining a contest over the right way to interpret 3519, the statute that Mr. Hartman has offered to the media and in an indirect fashion to this body. Now, in that case, excuse me, in that case, the specific language that they were looking at was Chapter 3, Article 5, Section 19, Subpart A, 6. And in that respect, they were trying to determine what the terms, quote, vacancy in nomination, close quote, mean. Because that's language that appears in 3519 when a vacancy in nomination occurs. Okay? The Supreme Court, looking at that language, this was Chief Justice Robin Davis writing for the court in that case, pointed out that, in fact, the statute really didn't contain its own definition. Some statutes do that. They'll give you definitions of operative terms that appear. It doesn't always happen. It did not happen when the legislature drafted and passed 3519. So what the Supreme Court said, and indulge me just a moment, please, to track some language, because I want to be accurate about it, and I want your honors to appreciate the full import of this decision by our state Supreme Court. Chief Justice Davis, writing for the court, said, when considering the meaning of legislative language, code provisions, we have held that the primary object in construing the statute is to ascertain and to give effect to the intent that the legislature had in drafting the statute. Once that intent in the statute has been ascertained, we proceed to consider the precise language that is used. In this regard, judicial interpretation, which is what your honors are doing in this case in respect to Mr. Hartman's argument under 3519, in this regard, judicial interpretation of a statute is warranted only if the statute is ambiguous. Thus, a statutory provision which is clear and unambiguous and plainly expressed will not be interpreted by the courts, but simply given its full force and effect. That's respect between the branches of government. So, they go on then to address the issue that was really before the court in that case, which was, what does this vacancy in nomination language mean? And I think and this is the point that's going to do away with Mr. Hartman's suggestion that 3519 somehow trumps everything that we have done to bring this election challenge before this body. The court said that there was no definition of vacancy and nomination contained in the statute, and so they looked to Black's Law Dictionary, they looked to their own case precedent, and they said that vacancy in nomination means pretty much what it says. And I'll quote one sentence, quote, "Thus, it is apparent that a vacancy in nomination signifies that at the time of the vacancy, the candidacy for that particular office is empty and unoccupied, i.e., there are no candidates for that particular office. There's nobody else to turn to, nobody else on the ballot." That was our Supreme Court giving judicial interpretation and controlling precedent to the term vacancy in nomination. And that is the critical phrase in 3519. Your Honors, what Mr. Hartman has done here in suggesting repeatedly to the media and to Your Honors that 3519 somehow applies here and has somehow trumped your jurisdiction under 376 and 377 is he is trying to distract your attention from the controlling law that we invoked in our petition and that mandates your role and function in this election challenge. And he's suggesting that this is simply something that comes up because we have a vacancy in nomination. You can't consider David Taylor's performance in the May 8th election. He gives you no reason for it because there is none. There is no law that says that David Taylor is ineligible. No one's ever challenged his eligibility. He was filed in a duly filed and qualified candidate on the ballot. You are sitting in judgment of this case. It is your unshakable, undelegable duty to render a full judgment on the integrity of the election that occurred in this county on May the 8th. So, where does this all leave us? Fact is, and Your Honors know this because of the certification that you issued on the 18th of May, you know that David Taylor garnered more votes than any other eligible candidate in the primary election. It is not only within your power, it is your duty to judge this election and declare what the true result was. It's a very simple process. Now that it's been established that Chief Deputy Kelly was ineligible, and if Mr. Hartman wants to argue that, and if you harbor any concern about that issue, consider only that he has withdrawn himself from the race. Take it either way, an ineligible candidate is no longer on that ballot. It's as if he never ran. He was ineligible. So now you have to judge what's left of that election. Was the election otherwise legal and proper? Judge it. That's your duty. It was. No one challenges any part of the May 8 primary election other than the eligibility of one candidate to be on that ballot. And that issue is now resolved by his withdrawal. So you look at that balloting that is otherwise legal and proper, and you respect the vote of the public here in Upshur County, and you declare the true result of the election for what it was. David Taylor garnered more votes. He polled more votes than any other eligible candidate on the ballot. He won. He's not trying to get something that he doesn't deserve. The suggestion that you don't have the power to grant him the relief that he seeks in his petition is just wrong. Don't have the power. I've taken you through the provisions in the West Virginia Code. You have a mandatory duty. You can't avoid the job that is laid before you by the code. You have to judge this election of May the 8th, 2012. It's obvious you cannot stand by the certification that was originally issued on May the 18th because now we know that Chief Deputy Kelly was subject to the Hatch Act, and for that reason he was ineligible to run. Believe him if you want to, that he withdrew because of his wife's illness. Fact is, he withdrew. He's withdrawn. You cannot certify him, you cannot affirm that original certification of him as the winner of the May 8th primary because he's withdrawn from the ballot. He's out of this. That's why I objected to his lawyer participating in this proceeding today. He doesn't have a dog in the hunt any longer. You have to judge what's left of the election after the candidate who polled the most votes withdrew. I submit he was ineligible. The federal government says he was ineligible. He withdrew. David Kelly had the most votes of those candidates that remained on the ballot. What we are asking this court to do is nothing more, nothing less than its duty under the law. To judge the election, to accept and recognize that Chief Deputy Kelly was ineligible and has withdrawn, and to declare David Taylor, the candidate who polled more election votes than any other eligible candidate on the ballot, as the winner. And then to amend the certification that was originally issued on May the 18th to demonstrate that there was a valid election held, and after resolving the ineligibility issue for one of the candidates, the true winner of the election was David Taylor. Publish that in an amended certification, give notice of that decision in accordance with the provisions in West Virginia Code 3-7-7. I won't take you through those notice requirements. It's not necessary. And then once you've done that, Your Honors, you can be confident that you have followed the law in discharging the duty that the law brings to you. I don't know how much precedent there is around the state of West Virginia for this sort of thing. You know, I cited you the Miller versus County Commission of Boone County case, where our state Supreme Court considered the statute that we're litigating under, 3-7-6, and held in part that that provision applies to primary elections as well. But there's not a ton of published decisions out of our state Supreme Court in this area of law. And I suspect that one of those reasons is, you don't see a lot of election challenge cases. The window for action is rather narrow. You have 10 days from the time that the county commission certifies the election result within which to file your petition. I would imagine that there are a lot of people who run for public office that cannot afford to have a lawyer, guiding them and counseling them and evaluating the legal aspects of an election in order to be able to make a timely judgment and get things filed within 10 days of the certification. I would submit to you that probably accounts for the fact that we don't see more election challenges being brought before county commissions. And so, not too many county commissions have trod this path ahead of you. And I think to an extent you can take some pride in the fact that you're doing something that other counties are going to pay attention to, and I think you can set a very strong, favorable precedent for following the law and protecting the integrity of the electoral process, because that's your function here. Is not to decide a dispute between two individuals as much as to protect the integrity of the electoral system here and judge this election, you and no one else. Had we waited more than 10 days, then the only option we would have had at that point would have been to go to the State Election Commission and complain. But that's not the case here. We filed a timely petition within 10 days after your certification on May the 18th. And that is the fundamental point that Mr. Hartman cannot get around, no matter how much he wants to argue civil service law and a provision under 315.9 that doesn't apply here because there is no vacancy in nomination. You can't get around the fact that we filed a timely petition that invoked a mandatory jurisdiction that resides here and nowhere else. I've taken a long time getting through all this, and I regret, the burden on your patience, but only a little bit, because what we're doing is that important. You can walk away from this case telling people you have judicial experience now in an official capacity. You're judges of this election. I ask you to simply consider this law, which clearly applies, the record that we've made here, and do your duty to judge the true result of the election and declare David Taylor, the candidate who polled more votes than any other eligible candidate, to be the winner. That will be the end of this case. Chief Deputy Kelly has withdrawn from the race. He will have no standing to appeal. If he should try to appeal, the court will simply ask him, what are you doing here? How do you have any stake in this? He has none. He can't appeal this. This will be the end. And the candidate who deserves the nomination will have it. And hopefully, between now and the general election, the citizens of this county will come to understand that the law does apply and the law is followed here in Upshur County. Thank you for your very kind patience and attention. That's all I have.
One question I would ask in reference to your statement of true result of the election.
Yes.
May we fairly assume that the third place finisher who you say was eligible would have lost to Mr. Taylor in a two-person race?
Yes. They were the only two qualified candidates on the ballot in the May 8 election. There was a third man, but he was ineligible. Whether you want to allow him to maintain the argument that he resigned for reasons unrelated to this litigation after he failed to get appointment to a new job in an effort to avoid the consequence of this case. If you want to indulge in that, I suppose that's within your power too. I would submit that that would be indulging an individual's pride at the expense of justice. But the fact is, and the inescapable conclusion is that you had an election in this county on May the 8th, and it was valid, save for one thing. You had an ineligible candidate on the ballot. That problem's been taken care of now. So now you have to look at the remainder of that election. And as judges of the election under the code, you're charged with the responsibility of protecting the integrity of the electoral process in this county. And to do that, you have to look at the election and say, well, we've got one candidate who's out now because he's withdrawn or was ineligible, both. We have two candidates left. Which one of them garnered the more votes? He's the winner. That respects the electoral process. That respects the principle of one man, one vote. And it follows the law, which is designed to vest you with this very responsibility to protect the integrity of elections in Upshur County.
Okay.
Thank you.
Mr. Harmon?
Thank you, Mr. Commissioner. I'm going to...
Excuse me just a minute. We take a short recess. We need to change our disc, our recording, so we'll just take a short recess for that purpose. Okay, Mr. Harmon.
Your Honors, if it please court, something I intended to say before I sat down before, that is, I would appreciate the opportunity to, since I'm the one representing the petitioner here in this proceeding, that I have the opportunity to make a rebuttal to whatever argument Mr. Hartman may offer to you.
Okay.
Thank you.
I have no objection to that as long as it's time limited in some fashion. I think the best way for me to start is to respond first to some of the presentation that Mr. Crooks put forward, and then present to you very briefly our case. First, I want to put some context into this. I mean, what is it that Mr. Kelly did? First, he did not administer any grants. I want to make sure that our objection to that characterization is absolutely clear. There's a grant administrator within the sheriff's office who supervises those, Rodney Rawlinson, and the sheriff does a great deal of that. The chief deputy, Mike Kelly, did not administer grants in any way, shape, or form. So what did he do? He got a paycheck from the county commission of Upshur County on a regular basis, the same way that chief deputies in Upshur County have been doing for years, and the same way that chief deputies in all 55 counties have been doing for years. So this allegation that somehow Mike has done something wrong, or that it's a criminal allegation, or that he has violated the law. Yeah, that's true. He violated the Hatch Act, but let's put some context on that. He got a paycheck from the county commission, which you three gentlemen signed on a regular basis. The county commission received grant funds, some of which ran through the state. The Governor's Highway Safety Program. Show me where the signal that that's a federal dollar jumps out to you. The governor puts his name on it and takes a heck of a lot of credit for handing out those dollars. But it's actually federal money that comes through that. If you take a look at the Secretary of State's issue as a booklet that you give each candidate before they go into election, they have one very small paragraph regarding the Hatch Act. This idea that somehow Mr. Kelly's notice or intent is immaterial is just not wrong. It matters. It matters legally because there was this sort of veiled, footnoted reference in the petition to a criminal allegation against Mr. Kelly. So it matters as far as the intent in that regard. It also matters as far as the U.S. Office of Special Counsel goes, because if there's a willing, knowing, deliberate, intentional act, then they take action. They seek penalty. They don't remove you from the ballot because they're not empowered to do so, but they will make sure that you're removed from your position, or that the county, if they refuse to do that, gets a financial penalty of some sort. That's what we're talking about. Let's put a little more context on the Hatch Act. It was in the 30s to make sure that federal employees were not participating in partisan political activity. And over the years, it has permeated into this. July 29th of this year, end of last month, the U.S. Office of Special Counsel was instrumental in promoting and pushing the Hatch Modernization Act, changing the Hatch Act so they're not fiddling with this kind of stuff every day. It went through its first Senate committee, the Homeland Security Committee. If that legislation passes, what we're here about today is absolutely immaterial. So I want to put some context on what we're talking about here. It's not the removal of federal funds, the misappropriation of federal funds. It's getting a paycheck from the Upshur County Commission every 2 weeks on a regular basis. The fact that he supervised people who were receiving federal funds. And in fact, he received overtime through those federal funds for a brief period of time. So I want to make sure that we get some context on what we're talking about and the wrongdoing that we're sitting in judgment of. The other thing I feel, again, I need to address, I think it's cynical or manipulative or disingenuous or just maybe misunderstanding of the law or facts. But the idea that Mr. Kelly withdrew in a recognition that he was going to lose an election challenge is simply not true. You have the letter before you. You know the fact of why he had the two choices available. He sought to find a position that was not subject to the Hatch Act and went and within the Sheriff's Department. As you are well aware, last week the Sheriff came before you to request your approval and you took no action on that. There's nothing illegitimate about that. The fact that he leaves the ballot, there's nothing illegitimate about that. And without betraying attorney-client confidentiality, the rationale behind that kind of decision was a personal matter. The idea of the fact that he would have to go to the private sector, begin obtaining COBRA that I believe, according to your county administrator, is over $1,000 a month. The fact that he may jeopardize his deputy retirement program that he's been building all these years. The fact that there would be no eligibility under the county's policy for a reduced rate of retirement insurance. Those are the reality of the factors in the decision. Not any concession that he was going to lose, and certainly no admission of wrongdoing or that he was ineligible. We stand firm on that point. I think we're right on that point. I think the law is right with us. I think the facts are with us, and you can obtain counsel, and you have, and you're paying him, and he's worth every single penny because he knows this law backward and forward. Now, as it relates to our case, what you're being asked to do is provide relief to which Mr. Taylor is not entitled in law. And what you're being asked to do is to, out of whole cloth, create new law. Now, I know you Republicans don't like activist judges. That's exactly what you're doing. That's what he's asking you to do. Don't follow the Supreme Court cases on point. Don't follow the existing statutory authority. Don't follow those things. Ignore the law and create this brand new remedy that's never been granted to anyone in this particular circumstance in a primary election. It's brand new. You're going to be, if you want to go where no man's gone before, go for it. But you'll be ignoring the law in order to do that. It's Mr. Crook's burden to overcome today. He shoulders the entire burden. We have none. We have none. Because what he is suggesting to you is the election that your county clerk already certified Mr. Kelly as a candidate. The West Virginia Secretary of State already certified Mr. Kelly as a candidate. The election by a 2-to-1 majority of Upshur County citizens voted for Mr. Kelly. They're asking you to overturn that, to ignore it, to put aside those things and declare him ineligible. We have no burden because you already said he won. You certified the election results. That's the status. He won. He was an eligible candidate. So they have the burden of demonstrating to you that somehow he was ineligible. And they're attempting to do that through a violation of 714-15. Again, as part of our motion to dismiss, I renew that motion. That section is not even eligible to Mr. Kelly. So you got to get over that fact. The current status of the law. That section is not eligible to Mr. Kelly. So you'll have to ignore that. You also have to ignore the fact that this is found in the civil service section of the code. You know, I agree that all these parts, all those books, no matter how disorganized they all read together. The criminal code that addresses criminal code is in the criminal code section. The civil service portion that addresses the civil service for chief deputies is in its own section because it relates to that subject. It's not found in the election law. It's not found in our Constitution, which is what the basis for qualification for the elected office is. It's not a qualification for office. It's a qualification to be a deputy sheriff, as it says squarely in that section. You'll also be ignoring the Sowards case. And there's been much hay made over the fact that the law's changed. But the Constitution and the constitutional principles that case articulates still apply. That hasn't changed. The West Virginia Constitution nor the U.S. Constitution have changed as regarding ballot access. It's not changed as far as you guys being able to make up new law. If the legislature has put it in the four corners, if the legislature has intended for something to be legal or illegal, they'll state it. You can't make up the in-betweens. You can't do that. In addition to doing some lawyering, I do a little bit of lobbying on the side. And I've handed to Mr. Crooks a copy of House Bill 2091. I have one copy to provide. I apologize, and I'm now giving all my copies away. But that bill gets introduced every year. Take a look at that. That's a 2091. That's a low number for this year's session. It means it's a re-enroll from last year. It's automatically re-enrolled from the previous year. And I'll bet you if you look back, it was the year before that, and the year before that, and the year before that. It is legislation intended to specifically include. It contains a strike and insert section, including chief deputy under the 714-15. It currently doesn't have chief deputy in there. In fact, it currently specifically excludes it. There's been an effort to include chief deputy in this legislation for years, and it goes nowhere. That's the will of the legislature, but it suggests strongly and intimates the fact that there is a need for that legislation. That means that the chief deputy is currently exempt. You wouldn't draft a code trying to include someone unless they were exempt. So you have to overcome not only the Constitution, not only the legislature, not only the voters of the county. You're going to be out making new law. And if you want to do that, that's fine. You don't have to believe anything that I say about this. We talked, I mentioned that earlier. You don't have to believe me on those points of law. If you want to find him ineligible, fine, do it. I think you'll be wrong, candidly. But if you want to do that, go ahead and do that. And if you do, there's more law on that fact. In fact, that's the section we're talking about, 3-5-19. It does prescribe what happens in these type of situations. It does trump your duty on section 376 that Mr. Crooks alluded to. This is a primary election, not an election to a general county office. The primary election, the code is quite clear on what you do. So even if I lose today in this election challenge, even if you say that he was ineligible, it doesn't mean that Mr. Taylor gets on the ballot. That is clear in West Virginia code. It covers both scenarios. If I win and you say, yes, Upshur County voters, he was eligible, he won, you got it right, but he withdrew. Sorry, you don't have your candidate. What you have to do is the State Election Commission then tells the Republican, Upshur County Republican Committee that they have to appoint someone. In the other scenario, I lose this case today, and you say that Mr. Kelly was ineligible because of his violation of the HAP Act. If you go ahead and find him ineligible, well, there's another section that covers that sort of thing. If he is disqualified because he was not eligible, 3-5-19 section 4 covers that scenario. The only thing is, it goes straight to the Republican Executive Committee. You don't have to talk to the State Executive Committee at that point. Those are the only two differences. The end result is the same. It's not Mr. Taylor that ends up on the ballot. Now, I think Mr. Taylor, I appreciate that he wants to be very much on this ballot, but that's not enough to make it happen. We've somehow had this procedure, kind of a tail wagging the dog, or it's inverted. Mr. Taylor has determined the result he wants to be the named candidate, and then has backtracked some legal reasoning and rationale to get there. That's not how it works. The law is quite clear. The Constitution is clear. West Virginia Code is clear. Supreme Court cases are clear on this point. The law is squarely on Mr. Kelly's side in this fact. If you want to make up new law, and that's up to you, but the existing law in the state of West Virginia is in Mr. Kelly's favor. He is an eligible candidate. He is subsequently withdrawn, but he is an eligible candidate. That concludes my presentation.
Yes, please. Hey, please, Court. When you're doing rebuttal, you have a couple of choices. One is you can take on the arguments that you heard in the order that you heard them, or you can start from the other direction and start with the last argument since it's freshest, and then work your way back. I think I'm going to go with option 2 here. Tail wagging the dog. That's an aphorism that rather struck me because if there was ever a tail attempting to wag a dog, it is a candidate who's withdrawn from a race trying to influence the litigation intended to correct a defect in the election that he caused. He ran illegally. He created a defect in the May 8 election to the extent that he was on that ballot. And he's now withdrawn from the race. And yet here he is. He's still here with his lawyer trying to influence you on what your duty is under the law. That is a tail attempting to wag a dog. My client is not asking you to make any new law. My comment in closing argument to the effect that there's not a lot of precedent on the books isn't entree to saying that I'm asking you to do something that's outside of the law. I'm not. There's nothing new in the provisions that we walked through very carefully here. 3-7-6 and 3-7-7, there's nothing new about that. It is express language used in a mandatory fashion. So long as David Taylor filed a competent, timely petition, which he did, he verified his petition, he cited the grounds that he relied upon to challenge the eligibility of Chief Deputy Kelly. He verified it under oath, filed it timely. He did everything that the law required for him to invoke your mandatory jurisdiction as an election court. That's not trailblazing. That's squarely within the provisions of the West Virginia Code. Nothing new or ambitious about that. You heard Mr. Hartman take another run at his argument that 315.19 subpart A4 somehow applies to this. He's wrong on a couple of points. Number one, he tried to say that we're beyond the primary election, that we're somehow into the general election at this point. He's wrong. You know he's wrong. Our petition was timely filed so that the certification that was entered on May the 18th is suspended. We do not have a final result declared. We do not have a final result declared for the May 8th primary in Upshur County election for sheriff. We do not. We have not reached finality in the primary election. Why? Because that certification that was issued on the 18th is subject to a challenge. Timely challenge, a competent challenge, a challenge that really there is no opposition to. All you have are head fakes and efforts to try and glide around all the points that actually govern and control the process and result that's required in this election challenge. In the course of Mr. Hartman's effort to suggest that 315.19 trumps, he even used the term that I used in my closing argument, trump. We all know what that means. Certain card games, there are trump cards. And that was the allusion to which I was making. And he even borrowed that phrase. The fact is, there's nothing in 315.19 that trumps your jurisdiction. And he can't point any language out to you in that code that does that. There's nothing in 315.19 that says, notwithstanding an electoral challenge under 376 and 377, if a candidate withdraws, you have to send it to the county Republican committee. It doesn't say that in there. If that's what the legislature intended, that's what they would have said. They didn't say that. Fact is, we filed a timely challenge, which brings us under 376 and 377. Had we delayed and filed out of time, then our only remedy would be to go and complain about the candidate on the general election ballot. But that's not the case. We didn't wait more than 10 days after the certification was issued on May the 18th. We filed a timely election challenge on the 25th of May. And that's what brings us under 376 and 377. Mr. Hartman has no answer to that. All he does is try to invoke language in 315.19 that applies to a different circumstance. And don't you know, I listened very carefully to his argument and was waiting to see. I was very curious as to what he was going to try and argue in response to the Tillis case that I offered to your honors. Recall the case out of Putnam County where Chief Justice Davis looked at the language vacancy and nomination, pointed out that 315.19 doesn't contain a definition of that term. So the court construed it. And the court construed it with common sense language. It means that there's a vacancy and there are no other candidates available. Obviously, that's not the case here. Mr. Hartman is attempting to try, I don't know why especially, but he's attempting to oppose our petition despite the fact that his client has no further interest in the case. He sort of gave us a little hint as to his motive when he cited to West Virginia Code 714-18, which makes it a misdemeanor to do what Chief Deputy Kelly did. And this, I think, explains all his strenuous effort at trying to argue that his client didn't mean it when he violated the law. Because he's concerned that there might be someone, I guess it would have to be the prosecutor in this county, who would try to prosecute him for an intentional violation under 714-18. My client does not claim to that jurisdiction. We simply pointed it out in a footnote in our briefing because it applies. It's pertinent. Personally, my client, I can say on behalf of my client, myself, I have no interest in seeing Chief Deputy Kelly prosecuted criminally under that statute. That's not the point of our petition. Our petition is directed at trying to correct a defect in the election that was held on May the 8th. That's all. The fact that his conduct may, raise risk for him under a criminal provision of the code, is pertinent for consideration along the way, but it's not the point of our case.
Well, then why did he raise it in a cowardly footnote?
There was nothing cowardly about it. I don't apologize.
Not even straightforward enough to make.
I object to this interruption in the midst of my argument.
Thank you.
Now, the fact is, the section of the code that we cite in our petition, 714-15, does not contain any scienter or mens rea elements in it. It's just simply a question of, is Chief Deputy Kelly subject to the Hatch Act? That's it. That's all. I don't have to prove that he knew about it, despite the fact that his lawyer acknowledges that, in the pamphlet he got when he signed up as a candidate, had a provision in there that explained what the Hatch Act is. So, he should have, if he'd have paid attention to all the requirements and the paperwork that the election office gave him when he signed up, he would have realized it. I don't have to prove that he knew he was violating that law. I don't have to. All I need to show is that he was subject to the Hatch Act, and he was. In fact, you heard in the course of Mr. Hartman's argument, I wrote it down, I think I can quote it. Yeah, it's true, he violated the Hatch Act. I don't need him to admit that much. The only thing that's required for us to demonstrate ineligibility for the May 8 election is that he was subject to it. His lawyer has made a judicial admission in these proceedings on the record that his client violated the Hatch Act. That's beyond what I even needed. Talk about cowardly. I'll tell you what's cowardly. It's cowardly to try and blame you, the county commission. You heard that in the course of Mr. Hartman's argument. You signed his check. You should have known better. If you want an example of cowardice in legal argument, I submit to you there is a very prime example. I agree with Mr. Hartman. The OSC has no power to remove candidates. They didn't try to. The OSC did not express any opinions on the correctness of the May 8 election. They did not presume to tread upon your jurisdiction. The history of the Hatch Act, yes, 1939, but it was extended to states, counties, and municipalities subsequent to the year of its original enactment. Arguing to your honors that there is a bill pending in Congress and there is a bill pending in the legislature in Charleston That is a true sign of desperation. We all know from civics class that bills get introduced in legislative bodies all the time, and a great many of them go nowhere. In fact, Mr. Hartman concedes that the bill he spoke of in the state legislature was reintroduced from the last session. It didn't pass the last time. It has no force or effect for this case to suggest that a delegate or a member of Congress someplace has sponsored a bill for future consideration. If ever such a thing became law, it would be long after this case has been decided under the law that exists right now. That is nothing but a canard, a distraction. The other comments that I thought were instructive here was the concession that, in fact, Deputy Kelly received overtime pay from federal funds. This kind of relates to the issue of administering programs. You all know that the chief deputy serves as the sheriff in the absence of the sheriff, right? And that would include administrative responsibilities for all the programs that are administered by the department, the sheriff's department. Fact is, I don't have to prove that he administered, that he was the, let me take a fresh run. Fact is, I don't have to prove that Chief Deputy Kelly was the administrator for federally funded programs. I don't have to prove that. The only thing we need to show is that federal funds flowed into this county and through the sheriff's department. That's it. And that's the point of our exhibits. And this court knows it already. I mean, you're sitting as the county commission 99% of the time. And you know what your funding sources are. The fact is, the fact that federal money comes into this county and goes through the sheriff's office means that Chief Deputy Kelly is subject to the Hatch Act. And again, that's all I have to demonstrate is that he was subject. End of story. His lawyer knows it. His lawyer has conceded. Yeah, it's true. He violated the Hatch Act. That's more than I even needed, like I said before. Now, curiously, in the course of his remarks, maybe we can just attribute it to the spirit of the occasion, Mr. Hartman made a vain argument that his client was not ineligible in the primary election. Obviously now, after hearing all the law and the facts and the application of law to facts, you understand that he was ineligible. The OSC lawyers were right. He was violating the Hatch Act. His lawyer admits it. All we have shows he was subject to the Hatch Act. I'm not asking you to convict him of violating the Hatch Act. I'm not asking you to convict him under state code for knowingly violating the Hatch Act. I'm not asking for that. I'm not asking for you to do anything new to make any law contrary to the suggestion you just heard. In fact, I offered you the Miller case. The Miller case, which was decided by our state Supreme Court, Miller versus the County Commission of Boone County, decided October 2, 2000, where they said that 376 and 377, the statutes that we invoke with our petition, in fact do apply to primary elections. What's new? What am I asking you to do that's outside of the law? I'm asking you to follow the law that our court system has looked at and approved of. They didn't overturn 376. They didn't say it had no application to primary elections. None of that. They followed it. In fact, they interpreted a dispute as to whether it applied to primary elections, and they said, yes, it does. I'm not asking you to make law. I'm not asking you to do anything extrajudicial here. That's another canard, another false argument, another arm-waving, desperate tactic. I am simply making a very simple case here. Under 376, you've got that jurisdiction that we spoke of. It's mandatory. You can't shake it. You can't deny it. You can't walk away from it. You can't punt it to anybody else. You have to sit as the judges of the election that happened on May the 8th. You know, the flag is on the field. You have to review the play. You have to decide, were there too many men on the field? There were too many men on the ballot. One of them was ineligible. Now, is there any law that's been presented to this body here today that clearly demonstrates that because one candidate happened to be ineligible to be on the ballot, that you have to throw out the entire election? No. There is no such law. And we know 315.9 doesn't apply because there is no vacancy in nomination. You've got two other candidates on the ballot, eligible candidates who were qualified to be on the ballot. There's no challenge to David Taylor's eligibility or qualifications to be on the ballot. He ran fair and square. He had to come up against somebody who was ineligible to be on the ticket, somebody who enjoyed a very favorable reputation in the county because of his association with all these programs. That's why he's ineligible. That's what the law's about. You can't perpetuate fiefdoms where people running a department of the government, get themselves elected and reelected and hang on to control of county government in perpetuity, in part because they have the benefit of goodwill generated by their administration of taxpayer dollars. That's what the law is about. Your judges judge the election that was conducted May the 8th, as is your duty, and you'll see that you've got one candidate who was ineligible. It's not even denied. You don't have to
Yes, it
convict
is.
him. You don't have to convict him of an intentional violation of the act. All you have to do is declare that he was subject to the Hatch Act, period, end of story. And you don't send him to jail for violating a state statute. Now, I can't imagine that a county prosecutor would have any appetite for trying to make a case for an intentional violation of the law anyway. And you will have done nothing to help in that prosecution if ever there was an ambition in that direction. All you will have said is that by virtue of his employment in a county department of the county government that was underwritten in part by federal tax dollars, he was subject to the Hatch Act. For that reason, he was ineligible to run in the May 8th primary. In fact, I would submit to you, now that I think on it, I would submit to you that that's an essential finding in this case, given all the arguments we've heard here. I can't imagine, all the trouble that may come from letting him off the hook on that point, because then we'll have arguments that, well, they never said he was ineligible in the primary, therefore this is a general election challenge and it has to go before the state election commission or the county Republican committee. He will have hoodwinked you. You let him off the hook with respect to your finding of whether he was subject to the Hatch Act. That'll be the next entry in a totally unnecessary and expensive and wasteful legal proceeding. The evidence is in. You have it. You see it. You understand it. He was subject to the Hatch Act. He was ineligible to be on the ballot. The fact that he subsequently bowed out of the election is of real no legal import. The real question is not what he's doing now. The question is, was he qualified, was he eligible when he ran May the 8th? He was not. There's nothing ambitious, there's nothing new in the law about that. You're charged. 376 says you have the jurisdiction. 377 says you have to judge the election and declare the true result. What was the true result? We had an ineligible candidate. You have to say that. We had an ineligible candidate. We had two other candidates who were eligible. As between the two eligible candidates on the ballot, the one that pulled the greater number of votes was David Taylor. The election, other than Chief Deputy Kelly's participation in it, was a valid election. You have to respect it. Respect it. Thank you.
Thank you. Mr. Hartman, would you like your copy of the House Bill 2001 entered into the record?
Yes, please.
Are there any objections to that? If not,
Mr. President, that'll be labeled responded here, Exhibit 1.
okay. Okay, at this time, are there any questions from my fellow commissioners?
None for me.
No. Okay, anything else to be presented to the commission, on either side?
Your Honor, on behalf of David Taylor, we rest our case.
Okay. Okay, based on that, then these proceedings are closed. Thank you very much.